Hi, we're live on Facebook and looking at a webinar that I did on Wednesday night, which had some technical issues. So I thought I'd take the opportunity to deliver it here on Facebook Live for you. Today, I'm going to look at 5 simple steps to manage your risks as a medical practice owner. It's a question that I get asked a lot every week. And I think that some medical practice owners are nervous about a whole bunch of risks that they don't know that they don't know. So hopefully this webinar can help put some of those fears to rest. You'd be disappointed if I didn't start my webinar with this disclaimer. This presentation is for general guidance only, and legal advice needs to be taken into in relation to specific issues. And I say that every time I do a webinar, and it's true. The reason that I say it is because every legal issue has different fact circumstances. So it's impossible to give general legal advice that applies to everyone. So sorry, not sorry. Who's this webinar for? Who is it worth you sitting down and watching all of this webinar for? It's for any doctor who wants to understand and manage the risks and obligations associated with running a medical practice. In the next 45 minutes, you're going to learn about the risks and obligations associated with owning a medical practice. And you're going to learn the steps that you can take to understand and to manage those risks. You have a framework and strategies that you don't have right now. My promise to you is that by the end of this webinar, you're going to understand the risks associated with running a medical practice and have a step-by-step strategy to implement into your practice so that you can manage the risks. Does this sound like you? Do you ever lose sleep worrying about the unknown risks in your practice? I know I talk to a lot of doctors who do. Do you ever think about what might happen if a claim came through the door that you had never anticipated in your wildest dreams? And I talk to doctors that this happens to all the time. One recently in relation to a payroll tax demand that they got from their state revenue office that they had not expected at all. And it really threw them for 6. They were having to think about dramatically changing the way that they ran their 3 practices. Do you walk around thinking it would be good to get some clarity around the different risks that exist within your practice, but you're not sure how to? And do you want to grow a profitable practice and not be surprised by the unknown risks that might come out of nowhere? Do you feel so overwhelmed worrying about risks that you would rather put your head in the sand and never thinking about it again? Well, that's not the real problem, although it is a problem. The real problem is that you haven't implemented my 5-step risk management method. And once you apply it, you're going to be empowered to grow your practice because you know your risks and you know, more importantly, how to manage and mitigate them. So for those of you who don't know me, my name's Sarah Bartholomeusz. I run a law firm called Legal. And why I'm interested in doctors is I come from a medical family. Got a GP in my immediate family, 3 orthopedic surgeons, 1 general surgeon, a nurse, a physio, and a registrar. In 2015, I won a Telstra Business Women's Award for the startup category for my law firm, Legal. And I've written 3 and published 3 books on governance. 2 of them I'm going to talk about in this presentation. And the other one is this book, Growing a Medical Practice from Frustration to a High Performance Business, which has a whole chapter on risk, which I did refer to when I was preparing this presentation for you. I also am a podcaster. I launched a podcast last year called Accountants on Purpose. And the reason for that is the very first season was accountants that work with doctors. So there's 12 interviews there that I talked to a whole bunch of accountants who are especially interested in working with doctors. And it's interesting for you guys to listen to because A bunch of them have great stories about why they're interested and passionate about working with doctors as well. I've worked with over 300 doctors in the past couple of years, and ULegal only works with clients that have a purpose that's higher than profit. And doctors fall so perfectly within that, because you help people directly, and by helping you, we feel the ripple effect of helping others. Not a lot of lawyers can say that about their practices. So it's something we are grateful to do every day. So on to the important topic of the day, discovering the 5-step risk mitigation method. Here are the 5 steps that you must take to mitigate risks in your practice. But first, what is risk? I hear you ask. Risk is quite simply exposure to danger, harm, or loss. And this doesn't strictly mean the loss of income, profit, or property, but also damage to your reputation and the goodwill of your business. So importantly, risk management is not just about avoiding risk. You may very well identify some risks that you want to avoid at all costs, but we don't grow and learn by avoiding risk. Instead, we learn to identify the risk, profile its consequences, and make calculated choices about what to do with it. Your risk, as well as your risk appetite, is diverse as every person that watches this session. Even it can be diverse in your own family. I recently traveled, not very recently, obviously, we're not traveling at the moment, but traveled with my husband, who, when we were going through customs, the customs officer found some toothpaste that was over the prescribed limit. And my attitude to this was just put it in the bin. But my husband was willing to argue the toss about whether or not, firstly, it was a liquid, and secondly, it should be allowed, if it should be allowed through. That is not a risk I was willing to take. I was willing to buy more toothpaste at the end when we got there. So even within families, in certain circumstances, risk mitigation or risk appetite can be different. First, I'm going to go through your risks as a company director. This is something that I was slated to talk about at the Practice Owners Conference this year, because it's often an area of risk that doctors don't know a lot about. And when you move from being a ABN holding practice, just running under your own name, to a structure, a whole lot of different risks and obligations open up for you. So a company is a separate legal entity. It's got rights and responsibilities all on its own, and it has its own tax return. What does it look like? It looks like either your medical practice, proprietary limited, or medical practices these days can be run as trading trusts or hybrid trusts. And so a unit trust might look like the second one, and a hybrid trust might look as the third one. Some medical practices are still run as partnerships, which is a much riskier practice, way to run your practice. And if you are running as a partnership, I suggest you talk to your accountant about whether or not that's the most appropriate structure for you. I won't be going into the risks of partnership, although I've talked about it on another webinar before. So if you're interested in that, just hit me up and I can put a link to that one for you. So what is a company director? A company director guides and monitors the management of the company. And for most smaller businesses and smaller practices, most company directors are very heavily involved in the management of the company. So if you're not heavily involved, if you're in a corporatized practice that's got a lot of different owners, then you most likely have a practice manager, and their employment contract and any policy that you've got on delegation of authority will help manage that risk. but you can't get out of your director roles and responsibilities. The Corporations Act defines the meaning, and it's a person who's validly appointed, or a de facto director, or a shadow director, or an alternate director. And these different kinds of directors have different levels of involvement in your company. There could be an executive director or managing director who's involved in the day-to-day management and operations of the company, or non-executive directors who are more hands-off in the management and just provide guidance in relation to strategy, and then the management do the execution. De facto directors and shadow directors are people who might not officially be appointed, but might be acting in place of a director. And I talked about a client that we've got at the moment who could potentially be seen as a shadow director of a company that's been put into liquidation. So they might not have an official title like this person didn't, but they did control some of the and have influence over the board decisions. So there's some risk that the liquidator will look into that person and be interested to talk to them. What are a director's duties? So director's duties do fall into two main areas. There's fiduciary duties, which are directors' obligations in relation to trust. Fiduciary duties are to the company, and it is their director's duty to act in good faith and have a duty of care and diligence. A fiduciary duty is an obligation first and foremost to act in the interests of another and not in their own interests. As advisors, as lawyers, for example, we're familiar with fiduciary duties. Fiduciary duties are duties that are statutory duties are duties that are set out in legislation. And this includes, but not only, the Corporations Act. The other legislation that affects your duties includes workplace health and safety obligations, ASIC, and there's obligations under environmental law as well that require you or provide personal responsibility as directors of a company. So who are directors' duties owed to? We talked earlier about the company being a separate legal entity, and that as a director, you owe duties to a variety of stakeholders. So those stakeholders include your fellow partners, but also your clients, your staff, and the community in general. So directors should remember first and foremost that their obligations are to the entity, but also to those other stakeholders. Directors have a duty to act in good faith. So we'll look at the duties in a little bit more detail now. The duty to act in good faith is a statutory duty as well as a fiduciary duty. So your decisions as a director need to be made in the best interest of the company and for a proper purpose. The tricky thing about this duty is that the concept of good faith can change depending on the circumstances. It's a little bit like what I explained at the very beginning with our obligations as legal practitioners to give advice based on the circumstances. To determine whether you're acting in good faith, you need to consider your intention. Is it your intention to act in the best interest of the company? And would a reasonable person in your circumstances view your actions as being done in good faith? You need to exercise your discretion in a way that you honestly consider to be the best interests of your company. And there's no fixed rule at the moment as to how this existence of good faith can be determined, which makes it tricky. So The next one is the duty of care and diligence. You need to carry out your duties. You must carry out your duties, in fact, with a degree of care and diligence, and not be negligent in managing the company. The standard of care will vary depending on a range of factors, including what type of director you are and the size of your organization, your specific and personal experience and your skills, and the skills of your fellow directors as well. As an executive director, if you're working within the practice, you have the highest standard of duty that's owed because you're aware of the day-to-day actions that the company's taking. Directors and conflict of interest. So I'm sure you're all aware of what a conflict of interest is, but do you know how it applies to you as a director, and particularly if you're a director that works within the medical practice that you're an owner of? It overlaps with the other duties that we've covered and can be difficult to manage as if you're working within the practice. You've got a conflict as somebody who wants to earn money, as a practice partner, but also as acting in the best interests of your company. So that you might, an action you might take in relation to that is if because of COVID-19, your practice takings are down, you may need to take less of a salary to be able to make sure that your other team members and your other obligations are covered first before you're taken care of. What can you do to avoid a conflict of interest if you're having board meetings? Well, it's really one of those things that's all about effective communication. And rather, the way that you manage and disclose the conflict will determine whether or not you've breached any duty. So there's a list here on what to do. Identify that you have a conflict. And one of the things about how to do that was reminded to me of a meeting I was in last year when we were trying to work out if someone had a conflict. And someone said, being conflicted is a bit like being pregnant. You can't be half pregnant. You either are or you aren't. And it's the same with conflict. You either are or you aren't. So this slide has a number of ways to deal with it. And if you're moving out of the room during the areas in which you think you might be conflicted, that's an excellent move. And communicate and disclose is the primary obligation and way to avoid breaching this duty. Improper use of information. As a director and owner, then you will be given an opportunity to read highly sensitive material relating to the operations of the business. And this duty to use information is so that you're not allowed to gain a personal advantage or gain an advantage for someone else or cause detriment to your company. Something that came up in relation to this with a doctor I was talking to a couple of weeks ago was that he had started a new practice with 2 other owners, and there was a clear breach in this case where they had set up around the corner to have a conflicting practice where they were in direct competition. So this is a breach of their obligations to the company, and the director had some very hard decisions to make about what to do about the existing company and existing medical practice, which was in a fantastic location in a shopping centre. Should he stay in business with these 2 people? It's very hard to be in business, and especially in a company situation with people that you don't trust. Another example of improper use of information is the example of Steve Vizard when he was a director of Telstra. You might recall he used information improperly in relation to a company that Telstra was looking at acquiring, and he bought shares in that company before it was acquired. And when the business was bought, the shares went up, and he was banned from being a director for 10 years for that, as well as being publicly shamed, which really put an end to his director career. So there can be very, very large consequences from breaching director's duties. The duty to maintain confidentiality is also a fiduciary duty that's embedded in the duty to act in good faith. Fiduciary is a Latin term that means trust, and it arises when a person stands in a special relationship of trust, confidence, or responsibility in relation to their obligation to another person. As a director of a company, you have a fiduciary duty to act in good faith and to maintain the confidentiality of your practice's information. And the duty extends to your duty to maintain that your employers were aware of the nature of confidential information, and that it must not be disclosed to people, anyone else, the general public, or even in some cases, other members of staff. There's been matters we've worked on where some practices have been wanting to purchase another practice, and it's not appropriate for all staff to know that. So there are some cases where some practice owners take an extreme measure and they have all of their staff who are working on the project sign another confidentiality agreement to make sure that that particular project is confidential for other staff, so as not to distract people. And then if it doesn't go ahead, there's not a huge amount of disappointment and fragmentation in what people are working on and talking about. So confidentiality inspires trust, creates great relationships, and supports the integrity of your organization. All directors, regardless of under what capacity you've been appointed, have an obligation to monitor the financial position of the company, maintain proper financial records, report accurately to shareholders if they're not directors, and also regulatory bodies to prevent the organization from trading insolvent. So at the moment, there's a moratorium on trading insolvent, but it's not something that you should be not thinking about. The organizations that are getting ahead of this now and making sure that the banks are on their side and they've done future planning as much as is possible at the moment are the ones that are not going to be in trouble when this 6 months ends. So you've got a responsibility to understand the financial position of the company. In some cases, directors should be taking extra courses to understand the way to read financial statements. It's not something that we taught in law school. It's not something we taught in medical school. So it can be time and money well spent learning about that. What if I breach my duty? Well, there's varying penalties that apply, and they can range from fines to imprisonment. That can be as broad as the duties themselves. So a serious breach, which might involve gross negligence or recklessness, as well as offences with elements of fraud or dishonesty, can be criminal provisions and can also lead to imprisonment. So for example, making false or misleading statements if you're doing a capital raise to try and sell shares in the practice, or continuing to act as a director when you're disqualified. I acted many years ago in the case of a bankrupt who was running his companies and had his wife listed as the companies, and the federal court did not take kindly to that. The maximum period for imprisonment have been for certain criminal offences from 5 years to 15 years for reckless and dishonesty offences, breaching director's duties. And we've got a matter at the moment where I believe a practice owner has done that, and we will be reporting that practice owner to all of the authorities, professional bodies, ASIC, everyone, because they are in a position where they should have known better. And it is absolutely outrageous what they're doing, but it's it's out of their hands now. They put the company into liquidation. So our client, who is a shareholder, just has to go through the processes now to make sure that they get what they want out of the negotiation. And reporting this person is 100% what they should be doing as well, because people like that need to be taken out of trade and commerce. It affects all of us when people aren't behaving properly. So strategies in risk management, and I'll go through these for every step. The first 4 steps particularly: avoid, mitigate, transfer, and accept. These are the different strategies that we can take to manage risk. Here's some examples of how they apply as a director. So participating is mitigating your risk, because you are participating as a company director, you know what's going on, and you're helping make decisions. Making decisions in the best interest of the company is a mitigation strategy. Being diligent in carrying out your duties and responsibilities, being transparent, ensuring that the company has appropriate directors and officers insurance. If there's more than one director, this is highly recommended, talking to your insurance broker about it. It's often worth the investment, but it won't cover you for cases of negligence or recklessness. And also considering having a deed of indemnity and access, which was questioned a little bit in the webinar that I gave recently. What is that? It's a deed that if you've got multiple directors, you should consider having, because that deed will provide a promise that the company will maintain the directors and officers insurance. It will also give you an indemnity where if there's some breach by you, you're transferring the risk back to the company. And you can do that in most cases, but not where you're being reckless or negligent or criminal, in fact. That won't protect you against those things. And access. So if you're no longer a shareholder or director of the entity, it gives you about 7 years to have access to documents that you might need. And if you get called before APRA or a tribunal or some sort of organization that you don't expect to, and you need access to documents, then this deed is critical, especially if the practice has changed ownership and you don't have personal relationships with people anymore. So I wrote a book about this. If you're interested, it's called How to Avoid a Fall from Grace. It was launched in Times Square in 2015, and it's been updated to include the safe harbor provision. So if you think that maybe there's some financial issues going on with the practice, then you can call in a turnaround specialist to help with that. So this book's been updated. I'll pop the link to buy it in the notes underneath this video. And I'm sending everything out personally at the moment. We're all working from home, so I can sign the book for you if you're interested in buying it. It's available on our website. Step 2 is to understand that your staff are a risk. So I never recommend that people run a practice on their own, but staff, as well as being your greatest asset, are also a liability. You've got obligations under workplace health and safety. Every person who conducts a business does. You've got a duty to ensure as far as reasonably practical that the health and safety of your workers and others in the workplace, so your patients, people who come into work on your building, your IT team, are protected. There's little doubt that the spread of COVID-19 has had a devastating impact on work health and safety of all persons who come into contact with all workplaces, and in particular medical practices, because sick people are coming to see you. And my GP said that at their practice, they've already diagnosed 2 people with COVID. I'm in South Australia. We don't have a huge number, so people are still going into medical practices with this infection. Probably the wrong word. Virus is the right word. But individual workers, you should know, also have a duty of care to work, to to exercise their own duty of care for their own health and well-being and that of others. And I've seen very heartening pictures of practices putting up screens and having lines so that people stay 1.5 meters away, making sure people can pay without touching anything. All of these new measures are all in congruence with these laws and obligations. To comply with workplace health and safety laws, medical practices do need to understand and undertake risk assessments, which from the pictures I'm seeing you are, so I'm incredibly grateful for that. Undertaking more telehealth is part of that as well. Assessing, managing the risk of contracting or spreading COVID. In terms of managing those risks, medical practices just need to do what's reasonably practicable to eliminate the risks to protect the health and safety or minimize them as much as possible. That is part of it, but also you should know that in relation to COVID-19, that it has been held some over 40 years ago now that the contraction of an infection or infectious disease entering a worker's body in the course of their employment could constitute an injury. So that does give an extra highlight to making sure that anyone who could be at risk of getting COVID-19 should be and presents a risk should be very carefully managed from your perspective as an owner of a practice. So your staff are a risk. In summary, your obligations as an employer are that you're vicariously liable for the acts and omissions of your staff. Staff can damage your practice by starting competing practices close by and taking your practice list. Staff can damage your reputation in the community by speaking unkindly about you or your practice. And what can you do to manage these risks? Well, you can have written agreements with all staff. We see regularly practices that don't have any written agreements. Really, the person at risk by not having written agreements is the practice owner. So services agreements for doctors are important as employment agreements. Policies and procedures can also mitigate risks associated with employees, and as part of accreditation, you likely have a whole swathe of those under your belt already. What you might not have is a delegation of authority policy to ensure that you've got clarity in relation to areas of responsibility for what's expected of certain staff members. Can your practice manager go down to the shop and get milk? Can they get stamps? Can they buy a piece of equipment without your permission? At what point does their delegation sit, and have you got that documented? As I mentioned earlier, the 4 strategies in risk management are avoid, mitigate, transfer, and accept. How can you protect yourself as an employer? Proper agreements with staff, that's avoiding risk and transferring risk in certain circumstances back to the employee. Policies and procedures also avoid and transfer. Disclaimers and consent forms. Insurance is a form of transfer as well. Step 3, understanding your potential risks. Potential risks include this list, which I came up with for my book, How Growing a Medical Practice from Frustration to a High Performance Business. And they're all relevant today. Some of them scarily relevant. Pandemic is number 4. Under pandemic in the book is flight interruptions due to pandemic. So who knew that I was a futurist when I wrote that book 2 years ago? But running a business creates different types of risks and reward. Unlike patient and doctor risk that you deeply understand, there are many types of business risk, and risks can be internal or external to a practice. They can also directly or indirectly affect the practice's ability to operate. Risks can be hazard-based, like chemical spills, or natural disasters, which are uncertainty-based. or associated with opportunities, which could be taking them up or ignoring them. The types of risks that affect any business could be specific to your practice and your goals. Just like you do with patients, to effectively manage practice risk, you should think about and prepare for internal and external scenarios that may directly affect your business. So I've got in the list natural disasters, pandemic, legal, such as insurance issues, resolving disputes, contractual breaches, non-compliance with regulations. IMPROPER has a lot of regulations that it expects you to comply with, and liabilities, global events like pandemics and interruptions to air traffic, technology like computer network failures, problems associated with outdated equipment, or cybersecurity, which in times of pandemic, when people are not doing what they usually do, people who commit cyber crimes are particularly active at this time. There could be regulatory or government policy changes, which every business in Australia is being affected by now. Your practice, my practice, our local bars and restaurants, of course, personal trainers, everyone. Quarantine restrictions, carbon emission restrictions, tax changes, environmental, like climate change. I mentioned chemical spills, location of your work and property and equipment, like damage from burst water pipes, robbery or vandalism, security like theft, fraud, loss of intellectual property, cash flow shortages, clients not being able to pay because of this pandemic, rapid growth and rising costs in staffing can affect it, filling vacancies, suppliers who go out of business, issues within the business or industry that result in failure or interruptions of the supply chain. We're seeing that ourselves in the lack of items in supermarket, or the restrictions in what you can buy in supermarkets, even for our personal homes. Consumer preferences might change. You might find after this pandemic, people prefer telehealth, and there's risks associated with telehealth, and you might want people to come back in to see you. But my father-in-law, for example, lives in a small country town, has to drive to his GP practice, and he's loving not having to do that and just being able to pick up the script at the local Moonta Bay pharmacy and not having to drive to Kadena. Failures and interruptions in the delivery of power is a risk. Water, transportation. I'm having terrible problems with my internet because of the load on people working from home at the moment. So you can see I'm in my home office now. So they're potential risks. Sorry to scare you, but just like everything else we've talked about today, the way that we can think about them is by choosing to avoid them, mitigating them, transferring them, or accepting them. And some examples for potential risks are making sure you've got all your insurances in order. Agreements are all in writing, which helps to transfer and avoid risk. Reviewing your risks regularly where you can avoid, mitigate, transfer, or accept. And having backup suppliers helps mitigate your risks as well. If you've only got one vaccine supplier or one hand sanitizer supplier, one mask supplier, you're at risk. Thinking about backup suppliers is a really important aspect. So a quick recap, our first 3 steps: director-related risks, staff are a risk, and potential risks. So step 4 is thinking about indirect risks. You do have indirect risks in your practice. I mentioned before, supplier-related risks, vaccines and swabs, or masks and sanitizer is much more up-to-date example of that. We've got a client that's not in the medical space. They are a flower supplier, so they do beautiful arrangements for different businesses, and they change the flowers in and out on a regular basis. They look like new flowers. They are like fresh flowers. They are amazing. And I think I remember talking to them about this risk issue, and one risk that they had was that they had only found one supplier in China that they trusted to make the flowers to look as beautiful as the ones that they had from this particular supplier. And of course, that creates a risk, and they've seen that risk come with all of the factories in China being shut down in the last few months. So no supply chain for their new flowers. So how to manage that risk? Finding an alternative supplier in a different country could have helped mitigate that risk, and thinking about this in advance when everyone else isn't panicking to deal with these risks as well is really gives you an unfair advantage in the market. Patients being personally affected, so changed priorities. I talked about my father-in-law who loves telehealth and may not want to go back and may want to leave the house less after this pandemic because of the risk of his health being impacted by germs that are out there and there's no vaccine for at the moment. The general location of your practice might be affected, which would have nothing to do with you necessarily, but still have an impact on your practice. And once you've come up with your list that affect you, the strategies again are avoid, mitigate, transfer, and accept. How might you mitigate or manage indirect risks? Remaining as agile as possible, avoiding and mitigating, having good communication and relationships will help you to avoid and mitigate as well. So thinking about those things in a meeting with your fellow partners and with your practice manager can really help. And why I say not to do it alone is having the different way that people think about things is extremely valuable. And I found that out recently with my 7-year-old, had to write a policy. I don't remember in year 2 having to write a policy for school, but he did. So that was fine. We went through how to create a cup of coffee. And even in our own house, there was some dispute about when you warm the milk to be able to have the best tasting coffee. And even though it's a silly home example, it's a really good way to think about how the way that different people think about things can help you in your practice, because it can help create a different perspective about how we do things and how to get the best result. The book that I wrote about risk is called Kingpin, Legal Lessons from the Underworld. It's a book about drug dealers and how they think about risk. Drug dealers participate in a market that's completely different from ours, but that has huge risks for them personally, for their business, and for their families. And I found it so interesting thinking about our risk as ordinary business owners in relation to these drug dealers and how they manage risks in their business. And without knowing it, what they do is they have policies and procedures. And going through the 7 drug dealers and what they did well and what they did not do well. Actually, there's 8 drug dealers now, including the chapter that I included when we did a reprint was of the man who started the Silk Road, which was the first online drug dealing marketplace. And so his story is really interesting too, and more up to date probably than the ones from the 70s who grew enormous businesses. But the lessons from them are as relevant today as they were then. So this book is also available on our website, and I'll pop a link to it underneath this video for you as well. Case study of a client that we had who was worried about managing risks in their business. This is Dr. Jamie Lee. She's an extremely entrepreneurial doctor, and she was managing her family as well as being the main breadwinner in her family as well. She was super passionate about this idea that she had to start VirtueVax, which is a vaccination clinic that goes around to different childcare centres to make sure that the staff are vaccinated, because she saw that they were at great risk. They're low income earners, and it was definitely in the childcare owners' interests or managers' interests to make sure that all of their staff were properly vaccinated. So she wanted to take away the problem for them and bring it to them as well. So she was really worried about the risks and not knowing what the risks were. She couldn't get her head around them and she wasn't sure who to turn to for help. So working together with Jamie Lee, we worked with her to overcome all of her concerns and overwhelm. There's a lovely video of her on our website talking about her experience with us. So if you would like to look at that, you're more than welcome to. She passionately runs her practice now, free from those concerns. And we're so happy to see it growing and developing as well, Jamie Lee. So thank you for being one of our wonderful clients. Step 5 is to leverage an expert. If you don't feel like you've got the expertise in-house to do this, using an expert can bring new ideas, best practice and accountability. And it's a little bit like having insurance. You pay for an expert to do something that you don't know how to do, and it would take you an incredible amount of time to become an expert in. And one of the things about risks is it's really hard to know what avoiding risks is saving you. So putting something in place like an agreement with an indemnity, which requires your doctors to pay back any money that you pay on their behalf after a shared debt recovery obligation comes back to you because they haven't paid it, you just don't see that risk if you've managed it properly. So that's what we aim to do here at ULegal. And there are new ideas in your head that wouldn't be there right now if you hadn't made the time to come along today. Today, I promised that you would understand the risks associated with owning a medical practice and have a step-by-step strategy to implement in your practice to manage those risks. And here are those steps, what you're going to need to win. Understanding your director-related risks, understanding that your staff are a risk, understanding potential risks, understanding indirect risks, and leveraging an expert. So that's all you need. Once you implement this, you have enough to legally protect you and your fellow practice owners, whatever the future may hold. But protecting your practice isn't free. And I know that I've invested about $250,000 using experts that I am not to protect my practice. And now you have a choice. I can help by jumping on a 15-minute call with you to go through what the potential risks are in your practice, the indirect risks, and work out strategies with you to manage those risks. We'll figure out the next steps for you, and the cost for this call is absolutely free. Why am I doing this? Well, I'm not speaking at conferences at the moment, getting out. I am working from home, which creates that travel time. It's available in my calendar. I love giving back and taking care of doctors. I mentioned earlier why I'm so passionate about that. I've seen doctors being so busy taking care of everyone else all the time. In my family, I see doctors leaving on Christmas Day because they're on call and they have other people's families to take care of. I know that you might want my help to transform your practice as well. And if so, we can discuss that and see if it's a good fit for both of us. And if not, that's fine too. So who is this 15-minute call for? It's for high achieving doctors who are a partner in their practice. You want to be able to grow your practice on a stable foundation. You don't make excuses and you always find a way. You're willing to push past your fears because looking at risks can be pretty scary. You're willing to push past them to grow, and you are coachable. You're willing to make different changes, make different decisions to help your practice. And you're ready. I'm ready. Have a look at this website. It has a link to my calendar so you can book in for next week if you're around, if you've got gaps, but space is limited. So sign up now to avoid missing out. Some of the questions that I dealt with when I did this webinar last were because I can't see your questions on Facebook Live, I'll jump on and answer them straight after this. about safe harbor. So I've addressed that. If you do think that your practice might be experiencing some financial problems or issues, firstly, talk to your accountant and they can pop you onto a turnaround specialist if they need to, and they'll know what their flags are for that. Secondly, they asked about the deed of indemnity. I wouldn't recommend that for a sole practice, but if you've got practice owners, having a deed of indemnity, access and insurance will help protect you now and into the future. It is a lot like insurance, and they're relatively cheap to put together as well for lawyers to do that on your behalf. So reach out if you think that you'd benefit from having one of those. I run a Facebook page, which you're in right now. It's not a surprise to you, Legal for Doctors. If you do think that you know someone who would benefit from being in this group, please do invite them. I'd love to share with more doctors who will get value out of the content and freebies that we put in here on a regular basis as well. So hopefully that was a helpful session for you all, and hit me up with questions underneath this post.